Call the meeting to order. This is the November 17th, 2023 Child Support Commission meeting. We certainly appreciate everyone being here. We have some special introductions today, at least one certainly. So let's go around, and I want to start this off with introductions, asking Kurt Bryan to introduce himself. So, Kurt.
Well, hello, everyone. My name is Kurt Bryan. I will be replacing the wonderful Elaine upon her retirement. I've got 13 years of experience in child support and looking forward to the challenge and happy to be here.
Welcome. All right, glad to be here. Yeah, Elaine moved me to this end of the table. She's nice enough to not say this. On the other end, the light reflected off my bald head and it skewed the video. So I don't know if you can even see me at all, but I promise you I'm here at the meeting.
He's making that up.
On a serious note, we do want to acknowledge the service this commission of Judge Wisher. He was a valuable member of our committee work for a long time. I knew him first as a juvenile court judge, and then he moved, some people would say up to Superior Court bench, but moved to Superior Court bench and served his jurisdiction well there. He was a great guy and a great servant to people of the state of Georgia. I don't know if anyone else has anything they want to say.
I'd like to judge because Judge Weister was a partner for the Child Support Commission. He worked with us in the background a good bit when we were soliciting assistance and anything to do with statute review and so forth. He's worked with us. He had worked with us for several years, and we really appreciate his contributions.
All right, let's just go ahead and introduce commission members and then our guests. So if we'll start, Chuck, you'll start off.
Chuck Clay. One of the last two of the original members, I think. I don't know what that says about either my sanity or competency, but always a pleasure to be here. From Marietta, lawyer, lobbyist on occasion too. And it's a pleasure.
Thank you, Judge. Roger Tutterow, Kennesaw State University. Ready? Well, Elaine, I think.
Okay, Elaine Johnson, currently the executive program manager, retiring March 1st of 2024.
I'm Noella U. Alvarez. I'm the staff attorney for the commission.
Good morning, everybody. I'm Christina Scott. I'm a professional mediator and conflict consultant with my own practice, Covenant Mediation Services.
Good morning, everyone. I'm Katie Connell, member of the commission. I don't know when you were appointed, Chuck, but I think we might have been appointed around the same time. So
Three of us.
we can double check that, but
I don't remember.
I've had two children since being appointed to the commission, and one of them is about to be a teenager. So there you go. So good morning.
Mr. Chairman.
Yeah, my name is Bill Hitchens. I'm a state representative and I'm not a member of the commission, and I'm here for a case today to present some facts.
Oh, good. Certainly glad to have you. Our other guests, please introduce yourself.
Good morning. I'm Jill Sapp, and I'm here regarding the HB 499 bill.
And I'm just here for Jill.
I'm Michelle Barkley. I'm calling you Elaine for Noel. I'm all parties. And I'm Latona Lawrence. I'm program coordinator for the Child Support Commission. Darlene Small here with the AOC IT department.
Okay.
And Deontay Mayfield here with AOC as well.
Thank you. So next, I have the honor of swearing in. I'm sorry. Those on virtual. Still doing virtual these days, right? So if those folks who are with us virtually can introduce yourselves, please.
I'm Emery Palmer. I'm a Superior Court judge in the Coweta Circuit, and a member of the commission.
Good morning. I'm Ben Land. I'm a judge on the Court of Appeals and a member of the commission.
Good morning. I'm Houston Gaines in the State House over in Athens and part of the commission.
Good morning. I'm Connie Williford. I'm a Superior Court judge in the Macon Judicial Circuit and vice chair of the commission. And I will say that I cannot hear the folks that I do not see on the camera. When they speak, I cannot hear them.
Okay.
Yeah, we'll have anyone come up if they speak further.
Thank you, Judge. Dr. Venor?
I'm Jane Venor. I'm an economist and technical assistant to the commission.
Thank you. And we have Holly.
Yeah, and Holly Carter.
Good morning, Holly.
Good morning, Holly Carter, Deputy Legislative Counsel with Office of Legislative Counsel, here to help.
All right, thank you all for being here. So I have the honor at this point of swearing in commission members. I think all of them that are, Judge Jones is not going to be with us at all today. She could not make the meeting. Regina Quick, Deputy Commissioner at DHS, will be here shortly. She had another meeting starting at 8:30. The other members that need to be sworn in are here in person. So if we can, I guess, gather around the table. Example.
Good. Yes, please.
We have everybody here that's going to be sworn in. So if you will, I'm going to read the script. You will raise your right hand, please. I do solemnly swear or affirm that I will discharge all duties lawfully required of me as a member of the Georgia Child Support Commission to the best of my ability and understanding. I do further solemnly swear or affirm that I am not the holder of any unaccounted for public money due to the state or any political subdivision or authority thereof. That I am not the holder of any office of trust under the government of the United States, any other state, or any foreign state, which I am prohibited from holding by the laws of the state of Georgia. And that I am otherwise qualified to hold a said office according to the Constitution of the United States and the laws of Georgia, and I'll support the Constitution of the United States and of this state. So help me God.
I do. I do.
All right, you will come around and find your paperwork and grab it. I'm sorry, this is.
Ink pen. Another ink pen. So I will date it and notarize for you. And there is, your executive order is there for you to have a copy of for your information. And then you'll leave the oath of office with us today and we'll get the notary on it and send it back to the governor's office. Wonderful.
Glasses over on the table.
Roger did too. Just take your executive order. Let's make sure, sorry. There we go. Does that one have your name on it?
Yes.
We can see.
We don't have to usually do breakfast champions, you know? Coca-Cola and little chocolate. We don't.
So you for just a minute, you can notarize those later. Elaine, if you come up a minute and you can notarize those later.
Yes, I will.
I think he needs your help.
So Elaine commented to me this morning that this might be her last commission meeting. I said, no, I'm gonna call a special meeting before March 31st. Even during session. Even during session, she says no, but I should have known that the rest of the staff would prop me up like they normally do. They had something prepared. So what I have here.
Sneaky people.
Come on, Bill.
Okay.
What I have for you is a letter from the Chief Justice.
Oh, how nice.
It says, congratulations on your upcoming and well-deserved retirement. On behalf of my colleagues, thank you for your extraordinary dedication to serving the children of Georgia through your over 20 years of service to our state with the Department of Human Services, and since 2007 as the program manager for the Georgia Child Support Commission. Your unparalleled dedication to improving the lives of children through Georgia's child support system has been enormously impactful and demonstrates best service-oriented mission of the AOC. Whether shepherding the state through the adoption of the income shares model for calculating child support while through your collaborative efforts to work with judges, lawyers, and the public, you have charted a path of excellence and service to our state that will have long-lasting and generational impacts. In training countless legal professionals and members of the public on best practices for the child support calculator, and in leading training sessions, you have represented the AOC and the judicial branch with distinction. Through these many years, your cheerful disposition has comforted many professionals and overwrought parents who struggle with child support issues and reflects well on our judiciary. Of course, I'm also personally appreciative for the vital role you've played in the development of the Parental Accountability Court database and for your continued support in personally evaluating those programs. As you know, these accountability courts provide valuable services to Georgia citizens and elevate the role of the judiciary in serving others. We're also very proud of your efforts. While we all wish for you a wonderful retirement spent with your family, and particularly your granddaughters, Kylie and Kinley. Please know that our court thanks you for the vital role you have played in improving Georgia's court system. Thank you.
Oh, that is so sweet. A little bit over. Let me hold this up. A little overwhelmed.
All right, you take pictures and I'll.
Appreciate you so much.
It has been a joy doing this work. I mean, it really has been. It's been a sort of a life calling.
Okay. You don't, one more.
Oh, this is so sweet. Thank you.
We're giving you a standing ovation, Elaine. You just can't see us.
Thank you, Judge.
Now let's get back to work, right? All right, we would go now to Latoya to tell us how to conduct business today, if you will.
Thank you, Judge Key. And good morning, everyone. I am Latanya Lawrence, and I'm the program coordinator for the Georgia Child Support Commission. And I will briefly discuss a few rules to help us navigate the meeting today via Zoom webinar. The Child Support Commission meeting members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other panelists are designed as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. Also, anyone wishing to give public comment by speaking today may do so at the end of the meeting, after the completion of our agenda. Please state you would like to give public comments by typing the request in the chat. Once you're called upon, we will unmute your audio. For people in person, if you would sign, well, it's kind of a note on the sign-in sheet, if you like to make public comments today, and we'll go down the list. And our chair, Judge Key, will make the determination on how many minutes you're allowed to speak. And in conclusion of today's meeting, staff will post this recording on our YouTube channel, the Georgia Child Support Commission. I will place the YouTube channel in a chat shortly for everyone. Thank you, and I'll turn it back over.
Minutes have been distributed previously. Hope everyone's had an opportunity to review them. Are there any changes or additions to the minutes as distributed? The minutes stand approved as distributed. Right, we'll now go to item 3 on the commission business, beginning with economic subcommittee, Dr. Federer.
Thank you very much, Judge Keys. The Economic Subcommittee met on June the 21st and July the 26th, resulting in our recommendation of the new basic child support obligation tables for Georgia. They were approved by the entire commission at the August 11th meeting, and they will be forwarded now to the General Assembly, where they will be included in legislation during the session in 2024. Judge King?
Any questions, Dr. Federer, for the committee? We appreciate your work and the work of all your committee members. We move next to Statute Review Committee, co-chairs Katie Cannell and Judge Booker.
I don't want to speak over Judge Williford. I'm here in person and I'm working on pulling up my executive agenda. Give me 1 second.
Well, I know Judge Palmer needs
Yeah.
to leave here in 4 minutes, so maybe we'll let Judge
Yeah, let me go
Palmer
first.
go, and then
Yeah.
Katie, you can certainly speak over me. You're there, and I think that makes more sense.
Judge Palmer's low income subcommittee.
Yeah, thank you, Judge Key. We've been working on this literally for years. And we finally, at the last meeting of the subcommittee, voted unanimously, I believe, to approve a recommendation for the low income adjustment. And we're going to recommend to the commission that we remove the current low income deviation as it exists and replace it with a low income adjustment that would be in the calculator. As part of this new low income adjustment, we're going to recommend that the commission adopt one of Dr. Veneur's options. It was the 1500C option, and without getting into the weeds of that, I mean, Dr. Veneur's here, and Elaine and Noel can speak to it, but after much debate, I mean, that's the one we adopted. We're going to further recommend to the commission that the proposed low income adjustment be applied after additional expenses on Schedule D and E have been included. We had extensive debate about that, but we resolved that it was better to apply that after those expenses were included to get a more realistic number to deal with in the real world. And we're prepared today to present that to the commission for a vote, and intend to recommend to the General Assembly in this session that we replace the low income deviation in 19615 and replace it with the adjustment as I have described.
That is a recommendation of a standing committee. Does not require a second. Is there any discussion, questions? All right, all in favor, say aye.
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 Any opposed, say nay. Carries. Okay. Would we need one of our legislators to assign that to legislative council to be drafted? It'd be the next step.
Yeah, and we're actively working on that
Okay.
right now,
right.
in coordination with Holly Carter.
Perfect. Okay. Thank you all. Thank you, Judge Palmer.
Thank you. I'm gonna duck out, Judge, but I'll be back as soon as that other meeting's over, if I can.
Good luck on that meeting. That's my circuit. So,
Yeah, thank you.
yeah. All right. Let's go back then to Katie or Judge Wood.
Thank you, Judge. And to the rest of the commission, this has been a long time coming. I would say labor of love, but I'm not sure it really was at times. I don't think that would be fair to say. Just by way of background, in December of 2018, this commission authorized the formation of 2 study committees. We just heard from Judge Palmer, who chaired the low income study committee, and I chaired the parenting time deviation study committee. Now, if you'll think back to the world of 2018, that was pre-COVID, pre-pandemic, shutdown. No one had ever heard of virtual learning. And, we didn't have, we weren't utilizing neat technology like we do now, where we have a, hybrid meeting. That work began ultimately in April of 2019. Undoubtedly, the pandemic put some damper on it, but the charges of the commission at the time were for those 2 subjects to be reviewed, and studies were completed. They took longer than expected, but then again, nobody expected the whole world to stop turning for quite some time in the middle. There were lots of time and energy was put into those study committees by not only members of this commission and members of subcommittees for this commission, but members of the public, members of the bar, the judiciary, and interested people, including just Georgia citizens and parents. Ultimately, the Parenting Time Study Committee made a recommendation to the commission that, that Georgia look into making some pretty significant changes to how we deal with parenting time in connection with child support. This commission then sort of flipped that issue to the statute review committee appropriately, because that's where that's the next step. So the statute review subcommittee of this commission has spent, I guess about a year now, taking the results of the parenting time deviation study committee work and sort of trying to solidify what it is Georgia should do with that, with the results of that study committee. So the statute review subcommittee is making a recommendation to this commission to remove the current parenting time deviation from the statute and also referred to as our guidelines, and replace it with a parenting time adjustment. Of course, in this instance, using the words deviation and adjustment are terms of art, so hopefully everybody's familiar with those. We recommend to this commission that Georgia propose a new parenting time adjustment using a formula that, after extensive research, we found that the formula used by Minnesota and Michigan is what we as a statute review subcommittee are recommending, with an exponent of 2.5. I'm certainly happy to answer any questions, and we've got Dr. Benor on for anybody who really wants to get into the weeds of what that means. We're also recommending to this commission that the definition of a unit of measurement for parenting time, that Georgia adopt a definition similar to that of Oregon's, with some tweaks that the statute review committee has spent some time on, and that's reflected in our minutes and records. So it's our request, Mr. Chairman, that the commission adopt the recommendation of the statute review subcommittee to replace our current parenting time deviation with the parenting time adjustment.
Say first that there's no need on the part of the committee or any member thereof to apologize for the amount of time it took to get this done. Even in good times, it's good work. So
Thank you for saying.
Very complicated issue.
It is a complicated issue, and it's and it impacts a lot of people, and people feel very passionately about it.
Is that going to be included in the legislative package that we're talking about here for this year?
We will certainly make sure the legislature knows what kind of time and energy and the breadth and depth of the work.
But it is going to be legislation.
That's the idea.
And for those of us who were around back in the day, then as you remember, the original bill included this similar process. And as we went around the state that year, public hearings for technical corrections, it wound up that being taken out altogether because it was so complicated, difficult to deal with. So that's great work on behalf of that committee. This is a recommendation from the standing committee, does not require a second. So any discussion, any questions? You probably almost wish you had some questions. You worked so hard. You want to demonstrate your.
Come on, hit me with the questions.
And we have Dr. Benor with us, who can certainly assist with any questions, especially if any of the members.
Thank you. I think we're gonna, it's gonna still take some work, I think, to get it, across the finish line.
All right, no one has questions or any further discussion about it, I'll call for a vote. All in favor, say aye.
Aye.
Any opposed, say nay. Carries. Thank you. But let the subcommittees and for the statute review committee as a whole, that is great work. This will be I said like in Lane right now, this will probably be my last legislative session, even though I was just sworn in for another term by the governor. Then when I retire from the bench, then the next year I will offer my resignation to him if he chooses to take it. Yes, thank you. All right, so again, great work. I feel so good. All right, let's move then. We'll hold technology and calculator subcommittee unless you want to report, anybody on staff wants to report. Regina, it says tied up in another meeting and she's going to try to attend.
Okay, I can, Kurt, do you want to speak on her behalf? We have the notes on the agenda.
The technology and calculator subcommittee?
Yes.
The subcommittee has not met this year, but staff is busy with various tasks related to the calculator, including assisting the public with issues and training on the calculator, routine updates, maintenance, while security maintenance continues with the AOC IT department. Staff is still looking at simplifying the low income deviation calculator and ways to improve the collection of correct data for pre-existing orders on Schedule B. Staff is also working with AOC IT, developing a way to modify the worksheet form for use in the juvenile court cases. This process is being tested now, and training will be necessary for the juvenile courts by commission staff.
Any questions? All right, I want to thank Regina for her work when she gets here, but thanks to all the other people on the committee and certainly, as always, to staff. We'll move to the next item, discussion, commission legislative bill for 2014. And I'm turning that over to Holly. Well,
Sure. So as I was just mentioning, Wayne, Kurt and I have been actively drafting the amendment or the proposed amendments to the guideline statute. I see those in 4 basic categories: updating the basic child support obligation table, as Dr. Claro just explained. And then as we moved on to Katie's report, we're also proposing amendments to remove the parenting time deviation and replacing it with the parenting time adjustments. In that same fashion, we're proposing to remove the low income deviation and in its place, adding a low income adjustment. And then 4, the proverbial cleanups, which there are a few. I just want to recap so that we're clear as to the basic child support obligation table. Those updates are twofold. First would be to adjust for changes in child rearing expenses over the last 16 years. The second would be to increase the BCSO table's vertical axis, which represents the party's combined adjusted gross income, and to extend that from its current 30,000 cap to 40,000 cap. So that means anytime cases exceed the combined adjusted gross income of $40,000, the court would then contemplate a high income deviation. Because certainly there are not tons and tons, but lawyers tell me personally all the time that there are certainly cases where combined adjusted gross income, even monthly, believe it or not, exceeds $40,000. I'm just looking at my notes here. Okay, I just want to speak quickly on the parenting time issue. The biggest issue with that deviation was that there's no guidance in the statute as to how to determine the appropriate and I think economically sound deviation amount. And so that was the need for a formula. And that's what brought on that change. I think most importantly, that formula will improve the statute by adding transparency, predictability, and uniformity on parenting time, on what the adjustment amount should be. So as to the proposed low income adjustment, that would provide a fail-safe at the very end of the child support calculation process to prevent a final child support obligation from exceeding a certain percentage of the paying parent's adjusted gross income. I'm not providing the exact percentage because it's on a sliding scale, and it's also based on the income level of the paying parent and the number of children in the case. And then, of course, the 4th was those proverbial cleanups. So that's what we're actively working on as we're getting through the sections, because you don't think something's related and you don't think something will affect another section. Oh, but it does. So we're getting through the statute section by section and then sending it on to Holly Carter for her to work her magic and formatting. So I also had presented briefly to the Judicial Council's Legislation Committee on Wednesday because they were holding their final meeting before the legislative session. And I foreshadowed what I thought would happen today. And what just did happen today is that you've authorized us to move forward with those 4 changes. So I think that's about it, unless Ms. Carter wants to report anything.
Anything you want to add?
No, just that we are actively working. We've already exchanged a draft for the items that we talked about in previous meetings, and we're just actively working on it, as Noel said. Thank you.
You have sponsors and that type of thing lined up that you have legislative sponsors.
Yes, it's my understanding that Senator Strickland, our 4 commission members who are legislators have already voiced their support and that they'd be willing to. We may draft
Sponsor here.
Chair Hitchens.
This is not my bad.
You're here.
All right, well, thank you so much for that. I'm really excited to see how it plays out in the legislature. And, of course, we just had the one session to get through the second year. Hopefully we can make that happen. As a reward to all the hard work. Regina, welcome. And, I told her when you had a late called meeting this morning at 8:30 that you'd be here soon. And we appreciate you being
I
here.
still know how to go to court, Judge. That's where I was this morning.
Okay. That's good. And, Kurt gave you the committee report.
Thank you.
Good show.
Appreciate that.
Well, I need to swear. Until.
And I think we finished with voting, but we do need to swear her in today.
Before you get away, we'll swear you.
Yes, don't leave until we do.
4 more years. All right, some new business. But before I forget, again, I'm old, so before I forget, this is not on the agenda, but just a quick update around legislation. As you remember, this commission had asked that the issue of legitimation be addressed. It impacts a lot of our work here. And I talked to Commissioner Gross this morning, and I'm authorized to say that it's anticipated, if you've attended the meetings of the Senate Study Commission, then you would know this, but they've had a strong interest in legitimation. It was talked about a lot at their meeting, most recent meeting in Columbus. They haven't done it on Monday, but the most recent was in Columbus. And they talked a good bit about it there. And it's fair to say that this is a reasonable expectation that something will be done this session around legitimation. I don't know what that's going to be. I don't know if Gina has any better idea than that, but that's what I'm sort of authorized to say. There was a lot of interest in addressing legitimation for all kinds of reasons. It could be very simple or complex. Anything you want to can say about that?
I don't know that I have any inside information necessarily about what may actually wind up in the study committee report, but I do know that we should have it by mid-December in terms of what the Senate study committee may recommend. There's been continuing discussion since last session. I believe I've mentioned at previous commission meetings that the department actually wanted to pursue an aspect of this last session, but there was not time in the session to do that. Since then, there has been continuing discussion on many fronts around the concept of what I will just refer to in shorthand as legitimation as biology, as opposed to the, dare I say, archaic, but certainly outlying concept, two-step process at Georgia.
Thank you.
Judge May,
Yes.
before we move on, may I recommend that we contemplate a motion for an e-vote if needed in lieu of a meeting in December or early January to agree on the final version of the proposed legislation.
Yeah. And do we need to make a motion to do the e-vote? Of course, can we just?
I think it'd be good to-
vote on the bylaws?
You typically we need a motion to do a motion for an e-vote, so it'd be great to just handle that here. That
That would be great. We have a motion that we address any legislative proposal that's coming out this work by e-vote.
yes, I move.
Second. Katie Canal and Chuck, first, and the motion is, any discussion around it? All in favor, say aye.
Aye.
Any opposed, say nay. Motion carries. Thank you. All right, so we'll move then to application of social security payments to child support and arrears.
Judge, we have Byron Cuthbert, the Division of Child Support Services, who can provide some insight on that. I don't know if Pat Bonadono is on the call as well. Pat, are you with us today? But Byron's prepared to speak on the points about that particular proposal.
Byron, would you introduce yourself and then speak to the matter? Byron, are you with us?
Yeah, I am. I just got to switch over. Can you hear me now?
Yes.
Yeah. So good morning, y'all. This was a legislation that was discussed and proposed between Pat and DCSS. The legislation is basically to propose an update to the guidelines about how to treat SSA payments, Social Security payments, and VA payments, where the payments are basically over the obligation amount. And basically, we're proposing to have the overage be applied to the arrears. This aligns with a new Court of Appeals case that just came out recently in Georgia, which is called, I want to butcher her name, Cocklaw versus Department of Human Services. And basically, the benefit of this proposal would allow for veterans and individuals receiving the SSA to decrease their arrears, and it also would allow for the state to get an increase in arrears payments. It also would provide clearer guidance on this issue because right now it's not covered for VAs in our guidelines. And sorry, that's it.
Yes, yeah, Chuck, that's just what I was asking.
Oh.
Staff. This appears to be an action item. And this is not coming out of standing committee, since it was taken off the agenda, right?
It was on the statute review agenda, but for November 2nd. So because that meeting was canceled, we shifted it over to this agenda.
Oh, that's what we did, yes.
To,
Okay,
right,
that's
to be able
that's
to
right.
figure out whether it can be included in the bill, the legislative bill.
So we will need a motion.
Yes.
I'll wait.
Katie Canal, made a motion and Chuck Clay is second. Any discussion about this? Any questions?
Good morning,
Sarah
everyone.
Austin has her hand up. I don't know if y'all see that.
Hi, good morning, everyone. This is Sarah Austin. I am on the Statute Review Subcommittee, and I'm also the lead counsel on the Colclaw matter. I'm with Legal Aid, and we were representing Ms. Colclaw, who is the payee in that situation. So I did, meet with my co-counsel and other attorneys at Legal Aid in the last couple of days to discuss, this proposed change to legislation. Overall, we feel strongly that it's a good thing, that it, tracks the holdings both of Colclaw and one of the cases we relied on in that appeal, which was the Reach case. Basically the holding that if a child or a payee on behalf of a child receives derivative benefits from the payor parent in excess of that parent's, support obligation, that overpayment can be credited toward arrears, or it can be credited toward currently payable support, but it can't create a credit toward future support. And so we feel like the proposed legislation is, consistent with that and codifies the holding that we were, hoping for in Colclaw. The only concern we had was that the new statute as proposed removes language saying explicitly that having payments from Social Security or another source that exceed the child support obligation of the payor cannot be used as a basis to modify the support obligation downward. So, essentially, if you have a child support obligation of $1,000 and the child receives benefits of $1,200, you can't come back and ask for a modification to reduce your obligation to reflect that. And, we feel that in the interest of the children receiving support, it's best that that language remain in, so that, in those rare scenarios that the support the child receives from a third party like Social Security exceeds their parent's statutory obligation, that the child gets to enjoy that benefit. But, we would like more time to, consider this and speak with the Statute Review Subcommittee about it. But we are glad that, I appreciate that the committee is taking this up. And, I didn't expect the Colclaw case to have this immediate impact. And I'm very glad that the commission is considering it so strongly.
Thank you.
You're very welcome. I need to head to another meeting, but I appreciate the opportunity to speak with you all about it.
Thank you for
Thank
doing
you. I don't think I'm speaking out of turn when I say that. I think the statute review subcommittee, obviously was, focused on the low income deviation and parenting time, but went ahead and, asked that this, action item be put on the commission's agenda, because, we know, or we anticipated, hoped, and now can say that we expect legislation to be going, to the legislature, proposed legislation to be going to the legislature to do, some pretty significant overhaul over our guidelines, and didn't want this to get lost in the shuffle. And we know that sometimes it takes a long time and can get hard, to get to the point of having proposed legislation drafted and presented. And we felt like this was something that the commission could potentially vote on to be put in with the draft legislation going in next year, as opposed to cycling it through another year of subcommittees, especially with the appellate case coming out in May, which was distributed to the subcommittee. So we are aware of that case. And really, I'd hate to see it have to take a backseat and get another year through subcommittee cycle when the issue seems pretty cut and dry. And, this commission does have the authority to move forward with it even without a full subcommittee review of it. And many members of the commission are on the statute review subcommittee. So it's not, it's just whether we're looking at it, wearing a different hat, but it would be many of the same people looking at it. So for efficiency's sake, I will move that that the changes be included in the legislation.
We haven't done it right, but it was DCS that did right. It's up to you.
That's a good point too. Yeah, and I will point out, Noel reminded me, it's DCSS, obviously child support experts, and Pat Bernardona, who brought this to the attention of the subcommittee and then therefore the commission. And as hopefully everyone knows, Pat served for a long time as counsel for the commission. So, and she's on this statute review subcommittee currently. So we're talking about, really knowledgeable people. I'm very comfortable with moving forward with it now, but if the commission wants it to circulate through the subcommittee, we can certainly do that.
Not at the moment, but we can add it. That's what we wanted the commission's approval of before adding it.
So we have a motion and a second to approve it without this language that they're looking for, right?
This would be to include this particular language, yes.
Is that a new motion though?
I'm not sure. Is that what you're saying?
Yeah, let's get some clarification. It's what the specific motion that's before, okay, that you made a motion to approve it. Does it include this language that she just talked about or not?
I think if I understood Ms. Austin correctly, she was asking us not to delete certain language. So I think the language proposed doesn't include that deletion. Right. So it's a double negative, but I think her request is sort of already captured in it because her request is to refrain from deleting. Am I saying that right? Yeah. So I think, so that wouldn't be an extra step or an adjustment to what we're asking for. She was just pointing out that deleting some additional language, she disagrees with that piece, but that's not included in this.
Well, but I guess the question is, at this point, do we need another motion to go forward for you all to include this Social Security veterans piece? Is that a different new motion?
I don't think so.
Included in what we've done?
I don't think so, but if Ms. Austin can clarify for us.
And I think she had to. Yes, I'm happy to. The only portion that we did have concerns about was the in the same paragraph that adds the let me pull it up real quick. I'm sorry. Here, this is the language.
Yeah, on page 9 of 47 of whatever I'm looking at.
And this is just yes. So let me see.
There's a line through. It's line through. Not.
It was the portion, yes, on page 9 of 40. It's 9 to 42 on my computer, but the only concern we had was the removal of "not" at the very beginning of the redlined area, where previously it stated that any amount of Social Security payments for the child's benefits, which are greater than the final child support amount, shall be retained by the custodian for the child's benefits and shall not be used as a reason for decreasing the final support amount. And, you know, we view that as a positive, that be a specific bar, that the payor parent can't use the fact that the child's derivative benefits are higher than their child support amount as a basis for reducing their child support obligation. And so we would prefer that not be used as a reason, you know, that clause remain in or be put in somewhere. We have no problem with the remainder of the proposals that, you know, any payments in excess of the parent's ordered child support can be used toward arrears, but cannot be used to create a credit toward future obligations.
So I think I understand this sort of now. So if we vote, what's proposed now, that motion deletes some language. We can,
Yes.
in fact, we could actually approve the motion to adopt this and then get a motion to amend to take out the deletion. Is that?
I think that's.
Correct. Yeah, it's really just that very first clause at the beginning of the red line portion, the not be used as a reason for decreasing the final support amount. So, you know, put that in or, you know, rearrange it to put that back in. And that was our only concern.
But maybe.
That right now there's that specific statutory bar to the payor parent seeking modification because of, you know, a higher Social Security amount. And we would like that bar to remain in place. And I apologize for my voice. I'm very hoarse.
Thank you.
All right.
Regina.
I was gonna say, I would ask, does Byron have a comment on that?
Yeah, so.
Byron, do you have a comment? And then Regina, Ms. Quick has it.
Okay. I guess that would be, because I get what she's saying. She says prior to the final amount, but she's still agreeing that would be applied to arrearages, correct? We still gonna apply the overage to arrearages. I'm trying to see. Yeah, I'm sorry. This is the first time someone brought this to my attention, so I'm trying to read it to understand her amendment. Shall be.
While you're reading it, Deputy Commissioner Quick has a comment or a question.
Thank you, Judge, and I'm just gonna respond briefly to Katie invoking the division as child support experts. They certainly are. This, however, is not agency legislation. It has not gone through the agency vetting process, which is a similar process to what the subcommittee probably would have talked about and discussed with specific language in front of it. This is certainly an important concept to bring before the legislature to deal with. The statute review subcommittee has been discussing it in general for some period of time, but this specific language has embedded in it many policy choices that legislators will have to make about how all this is treated. So with that said, I just wanted to be clear, this is not agency legislation. It has not been vetted through the agency.
Thank you, Regina. I'm going to propose, I know Byron may still be reviewing that, but I'm going to propose we take a vote on it as submitted, and then we'll address that deletion separately. So all in favor of approving it as submitted, say aye.
Aye.
The opposed, say nay. The abstentions, so that's approved. And now, does someone want to make a motion for discussion? Eliminating the deletion, essentially putting that language back in, which is what I think Ms. Austin was.
I guess, has that been vetted? I don't want to sound like a pro or con, but
No,
I don't know that folks are ready to do so.
It has not, and I will say, just sitting here brainstorming it, I mean, what would prevent a parent then from just, again, using easy math like Ms. Austin did, whose obligation is $1,000 a month, but the Social Security benefits are coming in at $1,200 a month. But it can't, so if it can't be used for modification, but it can be used for arrearage, what would prevent them from shorting their child support by the difference
And creating
the arrearage for themselves? I mean, not that I'm trying to give someone a map to where the safe is in the bank, but
Good point while you're here.
But it sounds like there's no real appetite for moving forward with that at this point, so we could address that.
I would feel more comfortable if that were vetted at another time.
Right. So this could be addressed when the legislative package comes out. as a potential change at that time, right? Okay.
Makes sense.
Any further discussion then on that issue? Right.
Judge, just so the record's clear about this, I want to make sure, I don't think the division. I'll let Byron speak for himself, but I don't think the division submitted this as for the division's proposed language either. I have stated in the past that I think there's some benefit to giving judicial discretion in the area of how the overpayment would be allocated in any given factual situation, whether as a credit or as a gratuity, as some of the case law might suggest. So I think that's a policy discussion that needs to be had at the appropriate time by the appropriate.
Judge, are we gonna circle back to 499?
Did I skip that? Oh, I did. I was looking for it down here, so I apologize.
It's okay.
So we're gonna go back then to jump down to new business. So let's go back to discussion of HB 499. We have a handout. And Mr. Chairman, would you like to speak?
You know.
Oh, yeah, but let's get Noel first to kind of refresh our memory around 499, and then Mr. Chairman, give you a chance to speak.
Perfect. Thank you, Judge Key. So HB 499 was filed during the 2023 legislative session, and we're lucky to have one of its sponsors here with us today, Chairman Hitchens. In part, HB 499 proposes to extend the duration of child support past the age of majority if a child is deemed disabled as defined in that statute. The commission heard from government benefits experts, a concerned parent of an adult disabled child, Ms. Jill Sapp, who is again with us today, and a legal aid attorney during our August 11th, 2023 commission meeting. Last meeting's agenda did not allow for time for discussion on this matter amongst our own commission members. And we just thought we would put this on the agenda again, or Judge Key wanted this on the agenda again, so we can have for possible discussion and questions.
Well, let me just say first, I apologize for not being here in person the last time. Dealing with my second round of COVID, and I in fact passed out walking across the parking lot at the Weston Hotel in Savannah. And was in bed, and I put on the coat tie and had my pajama pants on, sitting at the dining room table, and when I was listening to the discussion here, and I'm not even sure what I spoke about. But, this certainly is not in my bailiwick. I don't deal with this kind of legislation, never have, never been interested in it, never had any concern. But Ms. Jill Sapp, who I've known since she was a child, and I knew her mother, and I know her ex-husband, and she came to me with a problem, and I may not be an expert in this arena, but I know about inequities. And certainly, it caught my attention, and I can't believe that's what transpired in her life as fair and equitable. I mean, and I know she spoke last time, but she was married, got divorced. Her husband is probably in the top 3 or 4% of income earners in this country, and she got married young and was a housewife. Doesn't have means to provide very well for herself. She's selling real estate now, with the market is down. And she has a child that's on the spectrum. And he's like 19, 20. And very obviously the relationship between her and her ex-husband isn't very compatible. And he's cut everything off as soon as June 30th, I think, of this year. Even health insurance. He has his own family health insurance. And he could keep the child on there without any cost to him. And, the child goes to therapy every Monday and Friday. When he was on their insurance, it cost $50 copay. Now it costs her $500 every Monday and Friday. And she wasn't aware of that it cut off, and now she's in arrears for a considerable amount of money to try and make it back. And he's very disappointed that he can no longer go. But I know at the conclusion, I did hear some of the people that were making remarks about the case. One of them said it looked like a cookie cutter case. And it kind of is. But if we've done research, there are only 9 states in this country that don't have a bill like this. They provide for, it's common law, they provide for adults that are incapable of providing for themselves in all the other states. And as you see, Mr. Scott has done a lot of research and he's got all the information. I haven't had the opportunity to read all of it. I've read the summary. When Florida just passed a law that the governor signed on June 12th, and you see the summary there. I actually took it before committee, and we had a pretty spirited discussion. It came out, I believe it was unanimous for it. It was about to go to rules, and I've been on rules for many years, and I had every belief that it would probably pass. And I got a call from a lady from Department of Human Resources, and she told me that I was about to do that cause some dire consequences for some people with SSI. And that even as a fact could be a jeopardy, in that if she exceeded a certain amount for SSI, she would lose it, and she would have to pay back all the money that she had previously received for it. So I became very concerned and had several discussions with her, so I discontinued pursuing it until we could do some more research. I think, as far as I can tell, the Florida statute is a good statute. And I haven't read the entire 14 pages long. I haven't had the opportunity to read it all, but it passed unanimously both the House and Senate. And it provides provisions in there to make sure that the SSI problem goes away, as I understand. But I'm not a lawyer. I don't deal with this as my first introduction, and family law. This does have a good friend who is a family law attorney who's been working with her. She no longer does family law because of the emotional part of it, but he's trying to help us that through this. I'm very interested in getting done, and would like to go to legislative council today. I live in Savannah, and I don't make this trip up here any more than I have to. I've been doing it. I've been in state government for 55 years now, and I'm tired of riding I-16, I-75 on a regular basis. And I hadn't said this many places, and I hope Regina and Houston don't go back, but this is probably gonna be my last legislative session, and I'd like to see this come to pass before I get gone. And the only other legislator from my county is the speaker, and he doesn't carry legislation, so, I don't want to leave her hanging. But just like any of them, maybe a cookie cutter case, but very obviously it affects a lot of people across this country, and I'm certain it affects a lot of people in Georgia. If you're the custodial parent, you have no means except what you can provide in Social Security insurance and Medicaid. While the other party just goes off scot free. And in fact, there's very little contact between you and the son. But what are our options? What if she decides to give him up? Institutionalize him. He doesn't have a warm family loving relationship. And certainly children like this certainly need some of that to thrive. And then how much is it going to cost off the state? He's 20 years old. How long might he live, and how long will the state have to pay for him to be institutionalized? I mean, it's a real quandary, and morally, and I just feel I felt like I had to do something. I couldn't leave this on the table and just walk away. I think it's a serious matter that's going to affect a lot of people. We seem to deal with a group at home that called the Navigators, because they all have children with disabilities, and they work with one another to navigate the system. And those of you who work in the system know how complex it is. And even people, I don't think I'm the smartest person in the world, but I certainly have a capability to understand most things. And I'm at a loss when I read legislation about this issue. I mean, it's horribly complicated. So, We're just asking for the best treatment we can get and trying to get information to make it work and not hurt anybody. I certainly don't want to hurt people who live on the bottom rung of society, that Social Security insurance is a lot of money, but it certainly, that and no other income certainly diminishes the lifestyle of your staff and your child.
Thank you. Staff, would you come up to the table, please?
Yes.
Is there, Mr. Chairman, is there, and I, my ignorance, is your present legislation need to be amended?
Boy, it has to be rewritten.
So it has to be
When
rewritten?
I went to legislative council, she had no idea. She was perfectly frank with me. She said, I don't know what to do here. And she put something together on the spur of the moment, and I was only able to get it through committee probably. And there was a family law attorney in the committee, and she had some pretty probing questions, and I'm not sure I gave her the answer she wanted, but she was willing to go along with it. I don't know what would happen in the Senate. You know, Brian Strickland and Regina and I all came into the legislature the same day, and we've all been, Brian and I are best friends, and I was gonna get Brian to carry it, but he hadn't seen it yet.
So it's a new bill, there'll be a new bill introduced.
Well, I'm gonna probably leave the same number on it, but it's gonna be.
Gotcha. So you will have a vehicle that's theoretically there in the process.
It's there already.
And it'll be a substitute.
I don't wanna do anything that causes anybody any problems, but, you know, I wanna do something to help those people that find themselves in that kind of situation. I mean, I can't imagine what she's had to go through, and I know her. And, she's been a very dutiful mother, and she certainly stood up for her son and worked hard to try and make sure that he has a loving home and a good life, as he can.
Colonel,
If I may,
you
we're-
model it on the Florida statute as opposed to the current bill.
Oh, yes, yeah. And it's in, she provided a handout, so we all that information in Florida bill. And like I said, it passed, it's in the House of the Senate.
In the Florida bill,
I'm sorry, go ahead.
in the Florida bill addresses the SSI issue.
You're right. And that's a big issue. And I don't know how it falls out, but somehow, it would cause some issues with some of the people who are on SSI. The bill that we proposed. Like I said, the legislative council, he never dealt with anything like this, and he was just trying to throw something together.
Are you familiar with it? Okay.
Yeah, two things. One, just the folks on Zoom are asking that we all speak up a little bit. Also, I will note that the Florida statute, that is quite comprehensive. I've looked at it briefly. It does not deal with this within the child support guidelines statute, and I think that's really important to note. It is a separate form of support. The HB 499 that was filed last year sought to achieve what you're trying to achieve by amending the guideline statute, and Florida at least has already determined that is not the appropriate place to achieve what you're trying to achieve.
So your recommendation is?
I actually think from what I briefly looked at from the Florida statute, I think it was quite comprehensive and well thought out, addressed the benefits issues that folks had raised previously. I mean, I think it would be a good model and a good place to start.
That would be like, I think it'd almost be better served having it the standalone legislation, to be honest. And maybe I'm wrong.
Well, it's no problem. I started all over.
No, but it's great to hear where it's personal. Well, commission speak for itself. I'm speaking up, so maybe somebody can hear. I'm not trying to shout at you, Bill. Shout back at me so I can't hear.
And in full disclosure, I know her ex-husband, he's given me $1,000 the last 2 times I've run, so, I mean, it's about ethics to me and morality, and, you know, I just can't imagine leaving a child like that,
Here you go.
Ms. Scott?
Yeah, and when I was here in August, I came and spoke in August, and I had no idea that this bill in Florida had just passed. But of course, when I got home and I started on all my research again, I came across it, right? And dug into this, and so I found like 8 different things of information that I sent up here, you know, that, I mean, I could send to any of y'all. And one of them is the actual bill. But, I just didn't know it in August, but it, I'm just gonna say just that I'm not talking like I did last time. But anyway, I'm just gonna say a few facts, if that's okay. Disabled children grow up to be disabled adults, right? And disabled adult children are still dependent on others for their care and support. And they always will be. I mean, it's just a fact. They do not emancipate. They're still dependent, right? I believe emancipation should be based on one's ability to provide for themselves. Rent, utilities, food, transportation, necessities. Emancipation should not be based on one's chronological age, right? Emancipation is because now you can go and provide for yourself, but these disabled adult children cannot. They're still dependent. They should never emancipate, right? And I do know that Florida has put in their bill that even, it can be from the beginning, like, it stated in a divorce decree that if you have a disabled child, they don't emancipate. It just continues, right? I guess until a death of that parent or child. And it even states that even if they already have, you can still go and file suit. So if it's 5 years later, 6 years later, and it's the law now, you can go back to the court and they have that discretion to say, okay, now, no, you need to help support that child. So, and another thing was most courts find that a parent does have a duty to support an adult child who is unable to support himself. And I just feel like Georgia should have a statute where the courts have the discretion to award support from both parents of an adult disabled child, along with in order to provide health insurance. Most health insurance policies will cover an already disabled child past the age of 26 years old, like it does a typical child. And, that, I'm gonna say burden, not that my son is a burden by no means, he is a blessing to me. But that burden should be on both parents, at least financially. I mean, I do everything emotionally, physically, spiritually. I mean, I do everything for him, and financially, but at least both parents should at least have to help financially. He is still a dependent, right? It's not right that one can just go, emancipation, and just go off and not even worry if that child's taken care of. So it's just a huge thing. And the health insurance, right? Why should this burden also be back on the state, right? I know it's all complicated with, I wish SSI and Medicaid was like separate, right? And it's not. So I know that's a problem, but if they could stay on a health insurance and you're getting child support, then the state does not have to provide for that child. And I know it may be funny because, it depends on the child support amount. You may have a child who got, $1,000 a month, right? Well, with SSI, they would get what is SSI now? You can't get more than 2,000, but I think it's going up some. It's not a lot, but anyway, they may elect to go that route, right? Because it would be more money than what they were getting in child support. But if you're getting more than that amount, you should have the right to say, no, I don't need the government taking care of my child when myself and the ex can do it financially. And for the health insurance, it would save the government a lot of money also.
Thank you, Judge Lane has a question or comment. Judge Lane?
Yes, I have a question. As you well know, I'm one of the newer members of the commission, so I throw this out there for the more experienced commission members. This is obviously an issue with great public policy considerations on both sides. So my question is that something that's suitable for our consideration, or should this just be something that goes directly to the legislature and bypasses us? What role do we have on an issue like this that has such significant public policy ramifications and consequences?
Thank you, Judge. Let me just speak as chair for a second, and I talked to staff a little bit about this to help me understand it. Now, let me say first, Ms. Sapp, is I have a better understanding of your plight today than I did when we were here in August. I'll say also that I've been a full-time judge for 7 years. I was a part-time judge for 27 years before that, and I did domestic relations work. And I found myself representing parents on both sides of this issue. But I have a better understanding because Monday night we had a listening session in my courtroom around autism for families in our community impacted by autism. And as a juvenile court judge, I focus on the child and the child's parents as defined under the juvenile code. And but the stories I heard from parents of adults on autism, with these adult children still being raised by those parents, were heartbreaking. Some of the most powerful statements we have made around that issue. So we really have a much better understanding than we did even before Monday night. Having said that, it should probably not be in 1915. Regina taught me a lot this last legislative session about, rules in the legislature about what you can and can't amend. I don't know if you're going to put it in a different code section. If you can use that same bill with a total overhaul, you have to have a different one. That's that way outside my areas of expertise. You guys know it better than me. I think it is an important issue, a very important issue. That should not be in 1915. In terms of what, getting to Judge Land's question, in terms of what we can do, we collectively are experts on child support. All the economics around that, cost of living, cost of child rearing, and all those sorts of things. The decision whether to redefine child for this purpose is a very important public policy issue that will have to be made by the legislature. To the extent that the expertise of this commission can come into play with that and help talk about what that looks like, I think we'd be glad to offer expertise. But currently, under the definition for child for our purposes, it doesn't fall within our area of jurisdictions, is my view. So I want to say that I understand it. If there's some way that our expertise can be brought to bear to work on this in some way, if it fits within our legislative mandates, I'm certain we'd be glad to do it.
Your expertise is what we want. I want to do it right, and I want to make sure that we don't have problems down the road with something that we didn't see coming. And like I said, this is brand new to me, and I've never dealt in this arena. I just felt like I felt compelled that I needed to do something.
And I think that would require an amendment to our enabling statute. Because we're specifically giving authority for child to find a further definition of child. So we want to help to the extent that we can, but the public policy issue is not ours, it's the legislature's.
Georgia is only one of 9 states that does not have anything on the books for, disabled adult children.
And the issue is very ripe and important. I technically agree with everything that the judge said. He's got a heck of a lot more experience in that aspect than I would. It's cart and horse. I mean, I think, again, I can't speak for professionals here. I would hope the folks here would provide, expertise. You're the one who's got to vote yay or nay, and your peers over there is exactly what the judge is saying here. But I'd certainly like to be familiar with, and I'd hope whatever staff that might reflect would be helpful. I remember when we started this whole child support, changing this percentage of gross. When I was legislator, I was there when this bill was passed as it is now, and I was very skeptical. I have changed my opinion because of the expertise and caring and concern that I've learned. So as a group, I can only speak for me. I'd like that to be available. I don't know when you get in the nuts and bolts of this, Mr. Chairman, that the policy decision overrides the factuality of your bill, because it took us years to make a change. However, it's the right path to be on. But that's up to y'all as to whether, gosh, we need to have a study committee and look at this, all the things that we would do, but don't let the issue go. That sounds to be terribly profound.
Well, just like, so I have applied for SSI, right, and Medicaid. Well, this is the thing, you cannot apply until his child support stopped, right? So I can't, I couldn't apply months in advance and say, okay, but on this day, it ends. You have to wait till it ends, and I've not heard a word. They said it could be 9 to 12 months. So in that time, there is no help. There is no Medicaid. So, and now with, his father cutting him off his health insurance, he cannot go to ABA therapy. And when is that going to start back up? Maybe 9 months to 12 months. He's going to age out of ABA therapy by then because of his age. So now he's missing all of this therapy. And I was even paying the copays. I was paying, it ended up being $560 a month copay for the ABA therapy. When he cut it off, for those 2 weeks we went, which ended up only being 2 visits, we now owe $1,406. That's just the difference with insurance and not. And like I said, right now, he can't even go to therapy because we can't afford that.
Well, the prices is obviously, here and now for you, and I'm sure for many other people. It may be that the impact and importance, your bill's in good hands. There's nobody gonna be better on doing the political business of this issue than this gentleman sitting right here. And if it passed unanimously or on both floors last time around, the sentiment would be you may well not need anything from here, but if it's gonna be a longer policy decision, please get direction for us. And I know these folks would be as helpful any way we can. But hopefully, knock on wood, your bill's sound and you get it where it needs to be. You're gonna outpace anything we could do or any study committee do and get common people like her.
Because the Florida bill does look really good, I feel like.
May I just add, to the extent that the family law bar is paying attention, which, and I certainly can't speak for the whole family law bar. But I am on the executive committee for the family law bar section. So what I will say is we are trained, this is Katie Connell's opinion, not the official, but I think I'm in all candor, we are trained to be leery of post-majority support for a disabled child because we don't want that child to become ineligible for some sort of government benefits. And so we in our CLEs and that kind of thing, in our education that we get, we are trained to stay in our lane, but know about this potential problem out there. So much so that I can give you an example. I just wrapped up a case of my own where there is a disabled minor child, but the parties are getting divorced and, sort of in anticipation of that child eventually reaching the age of majority, both counsel, we get on the phone with each other and we say, what do you know about this? Well, what do you know about it? And both of us, well, what I know is to get them to a special needs trust lawyer and to, issue spot and then send them to the right experts to make sure that we don't unintentionally draft a divorce settlement that provides support for this child into her majority that ends up, pardon me, but screwing her out of some benefits she might have otherwise gotten. And we just know enough to know that that's an issue. And then we send them to lawyers who do special needs trusts or, know the thing. So, so it sounds to me like you have learned, both back in August here and through with what Florida's done and that kind of thing, that issue spotting is what, you're going to run into. And so I would just, not that you're looking for a suggestion from me, but for the extent that you are and that you want the family law bar to be behind you, I think conceptually they would be, most of us who've been doing it for any length of time have had cases where there's been a disabled minor child. And so the question of how will this child be supported when he or she is no longer a minor is one that comes up. But we tend to kick the can down the road after we issue spot and say, just make sure you don't mess this child up so that they don't qualify for government benefits down the road, even with the best of intentions, where both parents are saying we want to provide support, but sometimes we understand generally sometimes you want to do it in a way that doesn't maybe look like support. Or so if you want the family law bar support, make sure you're ready to talk about how you're not going to thwart that, because what we're trained to do is look out for that and not mess up the child's eligibility for government benefits once the child reaches majority.
And that's what the lady who family law attorney on the committee brought to my attention when I presented.
Right, so I can't articulate for you exactly how it works. I know we heard about it in August, so I have a better sense of it now too, but you know, we're just trained to sort of, oh, you know, red alert, but then get out of the way, because, you know, because that's not in our bailiwick is.
And it's not that black and white at all.
I'm sure it's not.
It's, you know,
And I thought we were in good stead because Ms. Sapp's mother retired from Social Security and she's very adept at, she dealt with it for 30-some years. Thank you, both. Thank you. Thanks for hearing us, and certainly, as I draw the legislation and I'd like to pass it around and certainly we make any corrections or deletions or whatever we need to do to make it right. I don't want to go back and have it thrown out of court somewhere for some problem that we should have fixed.
yeah, I feel like at least there should be a statute on the, you know, whatever it is, right, the law books or whatever. You know, I'm just a common person, so I don't know. But where you could take it to court, right? But is that the point right now? There's not. So a judge will not demand that, right? Because he has nothing to fall back on to say he has the authority to say, no, you have to help continue supporting that child. And that's where the issue is. That's the big issue. That's why in divorce decrees, it's not written unless the other parent is like, oh, yes, I'm willing, you know, but reality, most of them are not. They're only going to do what they have to do and what they're made to do. And that's it.
Thank you.
So,
Thank you very much.
thanks for listening.
Colonel, good to see you, sir. I
Good to
look
see you,
forward to
Dean. I
your
haven't seen you in a
committee
while.
substitute.
Huh?
I look forward to seeing your committee substitute.
Well, you know, you're like me. My wife says I can't keep a job. I've moved around so much. But you made the rounds too.
Yes,
now.
sir. A cat with 9 lives.
Yeah. Well, we're still living anyway.
Noel?
So they've made their public comment and we have one person in the chat,
All right.
Wayne
Who
Sneer
wants to
has
make a public
asked to speak.
Yes. All right. See you.
Oh, Wayne's. Wayne,
Mr. Flair?
unmute Wayne so we can.
There we
hear.
go. Okay. Can you hear me now?
Yes.
So I was just listening to, and I noticed that HB 499 has been on the agenda for at least this session, last session. You know, I've kind of mixed emotions about this bill because I have an autistic child. Within 6 months of child support ending, his mother, who was collecting child support for me, kicked him out of her house because child support was ending. You know, I think that I've heard a couple comments that it didn't really belong in child support, this issue, and I think I would probably agree with that because one, like for my own health insurance, it only goes up to the age of 26, no matter what the conditions are. So some insurances, some private insurances do go beyond the age of 26, but that varies by health insurance plan. So it's not automatic. And I think Medicaid provides, my son's medical needs are provided by Medicaid. And I think that is, you know, that's provided the best option. And, you know, the other thing that kind of alarms me if we would include this in child support past the age of majority is things like life insurance that often judges require the parents to actually have if child support goes into perpetuity, you know, because of the child's disability, the cost of life insurance for those parties get astronomically higher as you get older, especially if you don't have a permanent policy, right? If you have a 20-year life insurance policy, right? And now you're on the hook for life insurance up through to you die because you have a disabled child on child support, you know, that does pose a a real cost on the parents. I'm still, reading through the legislation, I'm still, and I know it, have to be reintroduced, but, I have mixed emotions about it because I don't think it belongs. I don't think this issue belongs in child support in 19.6.15, like Judge Keys had said. So that's my public comment.
Thank you, Wayne.
See that there's discussion on thank you for having that.
We have, and I skipped out of order for the other item. So we're back to general public comments. Do we have any people wanting to make public comments?
Nothing, I don't see anyone further past Mr. Slier.
All right, it's this first time it's happened.
So.
Yeah.
We will need to, before we adjourn.
Oh, hold on. We just had somebody add their name.
Oh, we have
Just-
someone else.
Your Honor, we
Yes.
have, we just had somebody want to make a public comment.
All right, and who is that?
Mr. Raja Anto,
Oh, good.
are you ready to hear him?
Yeah, let's see what this time we have here. All right, sir, I'm gonna give you 3 minutes, if you will, starting now.
One, I would like to understand how we got to the $40,000 number relative to high income, as relates to the low income, high income. $40,000 high income, that doesn't even sound intelligent to make $40,000 the litmus test for affixing high income to it. It's just an epic fail on so many levels. Number two, as it relates to Social Security, and again, I couldn't really hear. I wish everyone would go to the microphone or had a mic or something, but my concern about Social Security and how it will be applied is it just seems as though there was an argument that that any excess could be applied to arrearage, but it cannot be applied, and the person, the payor, cannot get a downward modification, and it cannot be applied to as a credit. And it just continues. There's this narrative that is continually being repeated and recycled. It just looks as though the state wants to affix a status of a lifelong, a perpetual funding source, a whipping boy, if you will, to the payors. And in most instances, this is the father, the dads, the men. I just, if you don't care, if what you care about is the welfare of the child, then why would you have such a visceral reaction to a father or a payor, a non-custodial parent, wanting to get a downward modification when there is clearly an excess on the table? It just doesn't stand to. Oh, do I have 3 minutes or not? Because I don't want to lose my time. And then the last thing I want to say.
Excuse me, sir. So and I'll give some additional time, but we made the decision that 499 is not within the purview of this commission at this point. So we don't need any further discussion on 499. Is all I was trying to tell you. That it's not what we're doing on 499. We're not going to be part of 499 at this point. And so you're wasting your time talking about 499. Your first question about 40,000, you understand that's 40,000 a month.
The language that was used in your discussion was not solely about 40,000 a month. There was an and or in there. So if it's only 40,000 a month, then great, because most folks don't make 40,000 a month. But that is not what was stated. That was not what was uttered.
Right,
it was first. It came out as 40K.
So I'll give you another minute and a half for any other point that you have.
Well, the gentleman before me was talking about the disabled child situation and how that, but then your response just now was about we're not talking about 499. So are we or are we not? Because my final point was going to be about that again, about about the disabled children and how he said, he made some great points, is talking about the life insurance. It's just, we continue to go down this path of making it punitive towards mostly these men and these fathers. And I just ask, what happens? What's the difference between a senior citizen and a disabled child? At some point, you just can't continue to just put all the onus on these fathers and these non-custodial parents and just say, well, you don't have, you are excluded from life, liberty, and pursuit of happiness. If a good parent is going to want to do that anyway, any good parent is going to want to do that. But when you have the state involved, when you have those levies involved, it's a total game changer. And I just think that, you guys are doing some good things, but the one narrative that you keep on recycling and you have not found a way to address it in any meaningful manner is that you continue to land on making the payor, the non-custodial parent, the fathers, the dads, these burden bearers. And it is just not equitable. That's all.
Appreciate, we respect your opinions. Judge Williford, you have your hand up.
Yes, Chairman Key, it was not about that comment. It was just simply before we ended, I wanted to talk about quickly the work that the Statute Review Subcommittee did this year has been so heavily weighted towards the low income and the parenting time issues. But we did discuss some other things. In particular, one of the things that we talked about a lot was changing the terms custodial parent and non-custodial parent. And the commission may remember that there was actually a survey that went out that we recently decided to take that survey down because it had been up for, I think, in excess of 6 months. So I just wanted to state on the record, since this was our last official meeting of 2023, that those are still important issues that the commission is working on, but because of the intensity of the other issues and trying to get that ready for the next legislative session, those other statutory changes that we were discussing, we propose that those be pushed to a future legislative session because there's just not time enough to deal with everything. And so we had to sort of prioritize, but there are still some other topics, several topics of discussion that are going on.
Thank you, Judge Moon.
Yes.
Right. So that's really all of our business. The one thing I'm told I have to do while we're still in session, I guess, would be to swear Regina. Gonna do that.
Yes. Yes.
All right. Make sure you can hear you. Let's see if everybody can hear you. All right. Make sure we get on the record. Raise your right hand, please. I do solemnly swear or affirm that I will discharge all the duties lawfully required of me as a member of the Georgia Child Support Commission to the best of my ability and understanding. I do further solemnly swear or affirm that I am not the holder of any accounted for public money due this state or any political subdivision or authority thereof. I am not the holder of any office of trust under the government of the United States, any other state, or any foreign state, which I am prohibited from holding by the laws of the state of Georgia. And I'm otherwise qualified to hold said office according to the Constitution of the United States and the laws of Georgia. And I will support the Constitution of the United States and of the state.
I so swear.
Thank you so much. Sign it here for me, then the name. Keep it free. Sir. Any other business that comes before the commission? I will stand adjourned.
Thank you, sir. Happy Thanksgiving to all.
Too.